welcome to another live lunch convos today. Today we are going to be navigating the legal waters, and we're going to be exploring best practices for hiring, employee discipline, and separation. So I have some new friends here from Erie Insurance. So I have Meredith, I have Jennifer, and I have Nathaniel, who we are going to be discussing some best practices and some industry information. However, I want to give a disclaimer before we start. We want to remind everyone that this is for informational purposes. Even though our panelists are legal professionals, please still consult your own attorney with your specific legal questions and circumstances. So with that said, we're going to dive right in. So let's first get started by welcoming our panelists. Thank you all for being here today. First, let's talk about, can you describe what is like the best legal practices when it comes to interviewing and hiring candidates?
Sure, I'm happy to take this one. So when we think about this, again, just really broadly, not any specific legal advice, but just best practices, one of the words that comes to mind for me is consistency. So when you're interviewing for positions, it is really critical and important that candidates are getting similar experiences and similar sets of questions. Sometimes we see cases in the employment side develop, not necessarily Erie Insurance, but just across, the whole country and states, where candidates will make allegations that their interview experiences were different. So maybe one set of candidates was taken to dinner, the other candidate was not. One candidate was asked a lot of questions about their home obligations and children and things like that, and another candidate wasn't asked those things. So a really good, just across the board piece of advice is to be consistent in the questions you're asking, and also in the experience that you're providing to candidates in terms of what your normal interview process would look like. The questions don't have to be exactly the same. I think we know that that's really not practical. People will answer questions in a certain way that allow for some follow-up that maybe someone else didn't answer the question that way.
Right.
So you didn't have the same follow-up. So we don't expect or think that people would be robots and ask the same question no matter what. But the experiences really should be the same, and they should be focused on the qualities and what the person needs, skill set to actually do the job. To the degree that you start wandering off into other topics,
Right.
generally that's not a great practice, because that is where some of, I think, the problems sometimes can come from, both in terms of having different experiences and also getting into topics that really are not helpful later if you're being accused of making a decision based on that topic. Like, for example, someone having kids or being married or not married, or someone's age, or where they go to church, or sexual orientation, or things like that. So having consistent and job-focused interview questions and experiences, I think, are some really good strategies for employers.
Awesome. So consistency is key.
Key.
It's key. So to be consistent, I forgot to say that if you have a question, you can feel free to put it in the chat, and we'll try to answer those in real time. So my next question is, what are some key legal considerations to keep in mind during the recruitment process to avoid discrimination or bias?
Again, I'll take this one. We sort of have divided up our answers by topical areas. So the interview, the beginning part here is mine. Again, I think not legal guidance, but best practices suggestion for people would be, again, to stay really focused on the job requirements and what skill set that people need to do that job, and to avoid any types of listing either in the job description or in the interview where you're going far afield of those qualifications and requirements. So sort of similar what I already echoed, or echoing what I had said in the first, that I think if you're thinking through your questions, you should really be able, for every one of those questions you're going to ask in the interview, what is this connection between the question and some skill set or something you need to know how to do in this job? Because things outside of that can sometimes, even they are very well intentioned. One of the examples Jen and I talk about a lot in our training when we talk with folks at our company is somebody sits down for an interview and is clearly 9 months pregnant. It's very normal and tempting to say like, oh, congratulations, or when are you due, or something like that. The problem with that is it's a job interview, and the pregnancy really has can't have
Right.
under federal law, Pregnant Workers Fairness Act, and under Title VII, any connection to whether or not that person is offered the position. But
Right.
now you sort of have it documented that you talked about the pregnancy in the interview.
Mhm.
So I think sometimes things that we don't think of as being problematic can potentially be, and again, it's hard to be robotic and to completely ignore if someone says, oh, I'm doing, to say nothing and move on to the next question feels very sort of cold.
Right.
And it's not that extreme to do that, but it shouldn't be something that interviewers generally are bringing up. And also some other topics like that, things that are safe when there's downtime, to talk about the weather, and things like that are definitely safer to avoid questions veering off into spaces that are prohibited areas under EEOC for making hiring decisions. And those would be race, religion, national origin, pregnancy status, veteran status, age. All of those things are topics that really cannot be used as a reason to not hire someone for a position. And so to the degree that you don't allow them to become part of the interview discussion is good.
So I just want to piggyback on one thing that you said. You mentioned documentation. How important is it to document your interview?
So in terms of documenting, there's no legal requirement to document what happened in the interview. However, that documentation is going to be really critical and important to you in the event that you are, as an employer, challenged on a hiring decision that you made or didn't make. So it is a good idea to document your interview experience. Some people do that through matrices. So matrix where they're scoring people, they have the same sort of set of questions, and then they're providing a score, whether that A, B, C, or 1, 2, indicating to themselves, boy, they really answered that question on their experience, or the way they handled a challenging issue really strongly, or to even put notes to that degree, and then to hold on to those interview notes somewhere in a file for, a long enough period of time. 7 years typically is for employment documentation. Is definitely a good strategy, because then you're able to show in contemporaneous writing some of the things that you use to make that employment decision.
And if I could just add,
Sure.
so if you have documentation, I do think this would be a best practice. Document all the questions you're going to ask each candidate, jot down some notes for each candidate pertaining to the response they give for each question, have some sort of rubric grading system where if one of those non-selected candidates comes back later and says, oh, well, the reason why I didn't get this job was because I have a disability, or whatever the protected characteristic might be, you can go back to your scoring sheets and say, okay, let me look what was on there.
Right.
Oh no, we selected this candidate because they scored 100 out of 100 possible points because of this answer. The more objective factors you can bring in, the better. When Mary talks about skills-based questions, the questions for the interview, think about them ahead of time, do some research online. So if this role that you're hiring for, they're coming in to lead a team that, say, has some issues, like some infighting on the team, and you want someone who's going to be able to step in and take the lead, ask a question like, have you ever dealt with employees in the past who have had personal conflict? If so, tell us what the situation was and how you addressed it, how you handled it, what was the outcome. Get an idea of how that person is experienced in handling the particular situations you're looking at for your position. If it's a position where you want them to incorporate more data review, have you tell us about how you've used data in a project before, or what was the data that you analyzed and how did it factor into, what were the results and that sort of thing.
I think that's great.
Awesome, thank you. So how can employers ensure that their job descriptions are legally sound and aligned with industry standards?
Yeah, so this is still me, the interview side of this. There are increasingly across states pay transparency laws. You'll notice as you look at job postings on LinkedIn or other places, increasingly salaries are included. That's a state by state piece of legislation and rules. Currently in Pennsylvania, the state of Pennsylvania, there's no requirement that salary bands be included in the job description. However, if you are looking to extend that pool into New York, You'll want to make sure that you're being compliant with New York state law in terms of what gets included in the actual posting. So I think that's definitely something that people really should be attentive to. And that's an area of the law that's changing very quickly. A lot of change in that space. So I would advise that people do some research, get on like a SHRM or someplace like that, where you could get a state by state of what each state's requirements are for job posting information. Some states require salary and some states require what benefits are in the job. So in terms of, so in terms of the posting, that is definitely something people should be attentive to, especially because of our proximity to Ohio and New York.
Yeah.
That as people may want to expand those searches outside of Pennsylvania, they should really be attentive to those requirements. The other piece in terms of what to be attentive to what you're putting into the job description is that job description that you're putting out there, this is the job you're applying for, is a really important document, because it later could be the document that's used to show, well, this is what they told me the job was going to be. So if you're to the extent you're asking someone to do a huge portion of things or a lot of time or skills on something that was never listed in the job description, and then maybe end up making a termination decision because, boy, they're really bad at XYZ, and the candidate says, there was no mention of XYZ when you hired me for this job, those issues can become a little bit problematic. So I think a good strategy for avoiding those is to really make sure that your job descriptions are reflective of what the actual job is going to be, and that the key top things that people are going to be spending their time doing are included in that job description. And to the extent that there's certain soft skills, to Jen's point about conflict resolution, if that's going to be an important trait for someone in that position to be successful, or they need to be a good communicator, you should list that in the job description, because if later you're deciding that you don't want this person working there anymore because they're really bad at communicating, they have this job description sort of now to point to as one of the places to say, you never told me I needed to be good at that. You never asked me about it in the interview. And now you're terminating me because you're saying, I'm not good at that, but I didn't know that was something I had to do. So in order to avoid those problems, a very accurate job description that includes all the legally required pieces of information that need to be there is a good strategy.
And just to add on to that, when we think about position descriptions, it's also important to the extent we're looking at the Fair Labor Standards Act categorization of employees. So typically employees are considered non-exempt, meaning they're eligible for overtime compensation. To the extent you're hiring for maybe a more skilled type of role and want to claim that an employee should be exempt from that requirement, meaning you don't have an obligation to pay them overtime, the first place that someone will look if there's a challenge is that job description, because typically the most common exemption under the FLSA is the administrative exemption. So that's looking at confirming that they're performing certain administrative high-level functions. So making sure your job description reflects that is very important.
So I guess this goes back to you. When conducting interviews, what are some questions that should be avoided to stay compliant with employment laws?
I'll let Jen take this because I feel like a lot of these initial questions were mine, and Jen knows this area quite well. So
Okay.
Jen, I'll let you.
Sure. So Mary's mentioned a lot of them already. So any of your protected characteristics. So under Title VII, age, religion, sex, race, and also other statutes, age, disability status, and certain states have protections, your marital status, your familial status, do you have children, do you not, your veteran status, whether you're breastfeeding, all of those issues are covered as protected characteristics or protected classes. So you don't want to ask about any of those. So you wouldn't just start us, oh, what church do you go to? Do you have kids? I mean, and as Mary kind of alluded to earlier, it is really tempting to just kind of engage in small talk while you're waiting for someone else to show up, but try to avoid those sorts of questions if at all possible. Now, sometimes you just get a talker and they'll bring it up. They'll say, oh, I have 5 kids at home, and this one does this and that one does that. It's okay. Obviously, you don't have to say, you can talk about your kids. It's okay to just let them go and then just steer the topic back on point. And when we were talking about the documentation earlier, you certainly don't want to document anything about the personal circumstances that they bring up, because you don't want to, you just want to pretend, I don't know, and you just want to try to forget it as much as possible. The only exception to that would be if the person says, I have a disability and I need an accommodation. So then the question would be, okay, do you need an accommodation with regard to this interview right now? If so, you might need to stop, talk to them about what their accommodation needs are. Do they need an interpreter? Do they need a support person? Depending on what their, disability is, do they need extra time? Figure that out, and then you can resume or reschedule at a later time.
Awesome. So what role does background checking play in the hiring process, and what legal steps can employers take to avoid potential pitfalls?
Yeah, this is a great question, and this is also an area where there's a lot of change happening very quickly at this level. The rules in New York are different than the rules in Pennsylvania and are different than the rules in Ohio. As it relates to the rules in Pennsylvania currently, you are permitted to do a background check for the purposes of employment everywhere except Philadelphia, who does not want criminal background checks or does not allow criminal background checks prior to offers being made. So if you're hiring in the Philadelphia area or hiring from the Philadelphia area, you want to also be very attentive to making sure that you're not using criminal background checks prior to offers of employment. Pennsylvania also has some other restrictions on what types of convictions you can use or what types of criminal background check you can use. Using a conviction in a hiring decision is allowable to the extent that what that conviction was for was related to the job. And charges are different than a conviction. So if you do a criminal background check and you see in Pennsylvania that the candidate has charges pending,
You can't count those.
right. So there are state by state, this differs everywhere. So this is definitely an area that I think for your participants at Erie Black Wall Street who do want to do some type of criminal background check prior to employment or credit history check, you need to be aware that there are federal laws that require pre-adverse action letters and adverse action letters. Basically, think of it this way. If you're going to do a background check, you get this background check back and it shows 5 convictions for grand larceny, theft, and all of these things, and fraud with money. And you're going to put this person in charge of your bookkeeping. You're thinking, oh my gosh, there's no way. So what the federal law disallows is for you just to quietly, oh, we picked another candidate, and never tell that person why. If you are going to use what you found in the employment decision, you're required to issue something called a pre-adverse action letter to the candidate. And think of it this way. You could have had the wrong information when you did the background check. Maybe it was a junior and there's a senior, and it was the person's parent who had all these charges, and you missed the junior and senior on there. So you have this background check. Or maybe there's a person with the same name and something got screwed up with the social security number, date of birth, and you have a background check for somebody that's not accurate. And now this person who otherwise would have been hired didn't get the job, and they don't even know why.
Right.
Federal law requires that you issue pre-adverse action letters to those candidates, letting them know, hey, we did a background check. We found this. What say you? And they have an opportunity to respond back about those charges. It doesn't mean you have to change your hiring decision, but you have to let them know. So there are definitely both federal and state rules around using criminal background checks and credit reports and things that you must do. So if you are, as an employer, going to engage in that part of the hiring process, doing these checks, I would highly advise making sure you really understand what is required there, because there are some strict rules and they vary state by state, in addition to the federal rules. Jen also has a lot of experience in this, so I don't know if there was anything additional.
My recommendation would be to use an accepted vendor who does background checks rather than trying to do it on your own. You don't want to Google someone necessarily. Use an official approved sort of sanctioned vendor who would do the background check for you. And then you don't have to worry about, I messed up, someone else is doing the work for you. And then just follow the process with the pre-adverse action or adverse action letters if you are using any of the information from that background check to withdraw the offer.
Okay. So how can companies ensure that they are compliant with the equal employment opportunity regulations during the hiring process?
The most simple answer to this is do not make hiring decisions based on protected categories. It is impermissible to make a hiring decision based on any of the protected categories, and we've listed those several times. That is the most simple answer I can give to that. Is it is illegal to make hiring decisions based on protected categories.
So moving on to some other requirements, what are the legal requirements when it comes to offering an employment contract, and when may it be appropriate to have one?
So I'll actually take this one, give
Okay.
Mary a break. So under Pennsylvania law, there's really not a requirement to have an employment contract, but to your point, there could be some situations where it is valuable to an employer. And when we think about kind of what are the requirements for an employment contract, they're really no different than the requirements for a contract in general. There has to be offer and acceptance, which in the employment context is an employer offering an employee a job or candidate a job and that individual accepting. There needs to be mutual consideration, which again, in the employment context is pretty straightforward. It's the employer offering compensation, a salary and benefits for the labor or the work product of an employee. Now, the only caveat to all this is you cannot contract things that are illegal. So you can't, there's certain rights that an employee can contract away. For example, they can't agree to a salary that's below the minimum wage. They can't electively choose to waive their right to overtime. And there's some other restrictive covenants that are under Pennsylvania law illegal. When we think about why we'd want to have an employment contract, really they're in place to give you as an employer protections. So a situation where we see this a lot is if we think about a company that is hiring individuals in a sales capacity. So those sales individuals have access to client lists, trade secrets, and those types of things. So you might really want to have an employment agreement in place so you can have protection for your business, such as a non-solicitation agreement or a non-compete agreement, which will help protect your company and its customer base. And there's also things, certainly most businesses have confidential information, whether it's your trade secret or just general business strategy and policies that are confidential to you and you want protection. You can have them sign a non-disclosure agreement to protect those different trade secrets. But the other important thing to remember is when we contract, it's a two-way street. So there's going to be obligations on that employee to do certain things, but you as an employer need to consider very seriously the obligations that you have under that employment contract to make sure you're satisfying all those requirements, all those promises that you made your employee.
Having it in writing is pretty good and can help protect you in the long run, is what I'm hearing from a lot of our conversation today. So kind of going a different route here, how should employers handle disciplinary actions to ensure that they are legally defensible and fair to employees?
So I'll jump in on this one. So the number one piece of advice would be to have clear policies and expectations set out for your employees and to enforce them uniformly. I know we're probably, we only have like about 5 minutes left.
That's okay.
Okay, so I'm gonna try to make it quick. So it is always helpful to have an employee handbook if you can. Make it very clear what your expectations are for the employees. Don't, be scared to tell them what you want them to do. You're the employer, that's what you do. And make it clear what the ramifications are if they violate the policies. If you're going to have a progressive discipline for attendance, you can do that, but make sure you enforce it uniformly with everybody. The other thing I'll just throw out there briefly is, again, similar to the hiring process, all those protected classes and characteristics, can't use those in the hiring decision. You can't use those in the termination decisions either, or, disciplinary decisions. You can't base discipline because, someone has a disability and they can't show up to work because of their disability. It gets tricky, but those are things just to be very aware of.
When an employee needs to be terminated, what are the best practices to ensure the separation process is handled correctly?
So I would say in this day, we now have a lot of remote work. So if the employee is working remotely, I would say do it on a day when they're working remotely. When you have an employee in person and you're going to be terminating them, it always could get a little dicey with other folks in the area. You have to find a private area to do the conversation with them, to have that conversation. And then if it's possible to do it remotely, that's obviously the best way to do it in a day when they're not around everybody else. And then if you have things like employee ID badges, keys, access to the building, you're gonna want to make sure you address those issues right away once the employee is terminated. If in Pennsylvania, there is a legal requirement to provide a reason for the termination. The other thing I would say too, setting aside that legal obligation to provide a reason, an employee should not be surprised as to why they're being fired. They should know. You should have addressed it with them before. Of course, unless it's something like, you just found out that they stole $1,000 from you yesterday. Even in that situation, you're going to want to interview them and get their side of the story. Maybe they have some sort of an explanation. Maybe you're mistaken. So in most cases, that employee is going to know the reason for the termination. So when you say, I'm firing you because we gave you a final warning for performance last month, your performance still fails to meet the expectations of your role, therefore we're terminating your employment effective immediately. I would say know the law with regard to mandatory notices. In Pennsylvania, there is a mandatory notice you have to provide regarding unemployment benefits. That's standardized. You can find it on the internet. Same with COBRA notice. If you provide benefits, there's a certain obligation to provide notice of their insurance rights. Be familiar with those state law requirements. So provide a reason, shouldn't be a surprise, and follow your state regulations with regard to mandated notices.
So what are some legal ramifications that could happen if a business owner is not following these best practices or the laws?
Litigation.
Yeah, so you could get a claim filed under the EEOC, filed in any court of choice where there would be jurisdiction. If you are not following these policies, let's say you don't send that mandatory notice and the employee then something bad happens to them because they didn't know they were eligible for COBRA. So they missed their window to apply for COBRA. Well, they could sue you and then you might be on the hook for the cost of their health insurance because you didn't do what you're supposed to do. There are probably, Nathan's our COBRA expert, probably some other ramifications under the COBRA, under the ERISA statute.
Yeah, there's
for not
federal
providing the mandatory notice.
penalties and different things like that. So you have that litigation risk from the employee or former employee in this case, but also, governmental agencies, if they get wind of you violating a federal statute or even state laws, there can be investigations, audits, and then ultimately fines and penalties for that non-compliance.
And maybe looping back, I think it is a really costly and important lesson, the exempt, non-exempt wage claims. So I didn't know if you wanted to just highlight.
Yeah, I mean,
how
that's
problematic a wrongful designation on exemption can be.
Yeah, I mean, from a risk perspective, it is one of the kind of the highest risks you the employee payment space, because if you were taking the position that a certain role is exempt and not eligible for overtime, and then an employee in that role challenges it, they're not going to just look at that individual employee. They could look at every employee in that job grouping. So to the extent you have, 20 people in a role that you haven't been paying overtime, courts can look back, and if they determine that this was a role that should have been paid overtime, they can look back and require back pay for that overtime. And depending on the nature of the role and how much they've worked, it can be a very substantial.
And treble damages.
And depending, there's special statutory provisions that allow for treble damages in this case, and even punitive if it's egregious enough.
So we do have one question.
What advice would you give to local employers in creating a better work culture? How important is the culture in overall company success?
That's a great question. I'll start off real quick. So I think trust and communication, open communication and trust with your employees, with your team is key. Being upfront with them about the things you can be upfront with them about is highly important. If you have an employee population who thinks you're hiding things from them and keeping things from them, it's going to foster some mistrust. And then the morale goes way down and everything goes way down. So if you're open and honest with them, you have good communication, and you explain things to them. A lot of times employees get upset because they just don't understand why something is happening. If you explain to them, look, we have to, cut this benefit for next year because this is why. If we don't, this is what's going to happen. A lot of times the employees, if they just understand and if they're provided the information, they will understand and they'll react better to it. I would start with that, trust and communication.
Yeah, and another thing I think is important, even in small organizations, is performance assessments. I think that performance assessments help with culture, even if the performance assessment a person gets is not particularly great. It's showing to other employees that there's accountability at your workplace. And I think people being happy and having good morale in a workplace, there's often accountability that the people who are working hard know that their employer is going to reward that hard work and is not going to ignore, tolerate, accept lack of work.
Right.
So I do think that performance evaluations help check that box because people know that their work is going to be assessed. And even to the degree that it's challenging to give hard assessments or thinking that, you know, telling someone they're not doing a great job, I think the benefits long-term performance assessments are really big.
And I would say too, just make sure the performance assessments are accurate and accurately reflect your assessment of that person's work. Because if you have a person who's like doing terrible work and you're getting to the point, you talk to them over and over and over, you've got to improve, you've got to improve, you've got to improve, but their performance assessments are all glowing and great. And you finally get to the point where like, I cannot tolerate this poor performance anymore. I need someone who can actually do the job. So you fire the person. And they go to an attorney and they say, look, my performance assessments were glowing. I thought I was doing a great job. I think I was really fired because I just turned 65. You know, and then it's going to be a much tougher and uphill battle for you to say, no, their performance was really bad. Then why did you give them good performance assessments the whole time?
Yeah, don't do performance assessments unless you are willing to do accurate performance assessments.
Address those issues.
Yeah.
So I do have one last question for you all. Erie's Black Wall Street, we pride ourselves on being a resource hub for information. And so are there resources that small business owners can consult to be comfortable that they know correct legal practices during hiring, employee discipline, and separation?
I think one of the first places to start is government websites. Even when I was preparing for this, I found myself on some of the Pennsylvania state departments. They have a bunch of frequently asked questions. They have kind of employer specific guides. And, you know, for example, Jen mentioned the unemployment compensation notice. There's an entire web page that talks about why it's required, how to comply, gives you the sample and some frequently asked questions. So I think generally speaking, just poking around on various governmental websites and looking at those FAQs for employers is a really good first place to start.
I 100% second that. The Department of Labor, Fair Labor Standards Act, unemployment, pretty much any space you can get. The EEOC website gives you a lot of great information from the employer perspective to be aware of. Locally, we have the Manufacturers and Business Association. I believe that is a paid membership for employers, but they do have a lot of resources and they do provide a direct coaching, counseling, and I think sometimes even representation in certain areas if you're a member of their organization. I would also say too, I don't think you can overstate the value of going to an attorney personally, individually, getting that feedback, get everything in line, develop your employee handbook, have an idea of what policies you want, your pay, how you're going to classify employees, your benefits that you're going to offer, your hiring procedures, your interview questions, get it all together. And then schedule a consult with an attorney and see if they'll just take a look at it for you. An employment attorney would be able to review some of those things pretty quickly and just kind of red flag anything that they think might not be a good idea. So I think those resources online, the local resources, and then one-on-one attorney consults are huge.
Awesome. So I thank you guys for coming out today and just sharing this information with us. Like I said, we love being an information hub and a resource for people. And so we want to make sure that we are dismantling barriers that have been set up to not share information. And so I thank you all for being here today. I thank you all for tuning in. If you have any additional questions, please feel free to put them in the chat. Also, if you are interested in telling your story tonight, Erie's Black Wall Street has partnered with Voices for Humanity to hear the stories of Black Pennsylvanians. And so we're doing that tonight at the Historical Institute of Culture and the African American Experience. We invite you to attend and to share your story. I thank you all for coming out. Have a wonderful rest of your day.